Good morning, ma'am. You have a seat there. This is on for a presentation, and I did, let's see here, got that order. Did you get a copy of that order, ma'am? Did you receive a copy of that proposed order for today?
I did receive an email
Okay.
and it specified 3 different sections.
So this was the one that would have, you should.
But I'm not really sure the process of, because Aaron no longer represents me.
Correct.
And I'm trying to obtain some type of legal service through Northwest Justice.
Okay, this is an order that actually is out of a hearing back in, we had this hearing, this was previously, was back
I think
in
originally
April.
March was the first one, and then it's slightly modified by the last hearing. So I just sort of left off the date since it's a bit of a mishmash of the 2 dates.
Mhm. This, I did review back through, this does appear to be in conformance with the order as we modified it the last hearing. And it does set a review September 17th. I did see an email from Miss Call, who didn't recall everything on this. This is what I recall, so I'm inclined to enter this hearing order.
Okay.
So I will enter that order, and you'll need to work with Ms. Fellows as far as doing the visitations.
I was actually going to request someone aside from Miss Fellows. I think Charlotte Roos was someone that we were hoping to use. And
Who?
I think Aaron was the one that had proposed that long time ago back, because we've been doing this since February.
Charlotte Rosen's doing the reunification counseling, so that's
Right.
That's
To use her.
That's a separate issue, and I haven't ordered that at this point. This was just a visitation supervision.
Right, to use her for the counseling and for that, to reunify them.
I don't think we've ordered that, though.
It is ordered. It's previously ordered. It was an agreed order that was entered some time ago.
Okay, I don't recall that issue. The only thing that issues in this one was the visitation through Miss Fellows.
That's correct. That's the only thing we talked about at the last hearing.
But Your Honor, may I say something, please?
Sure.
So why we're here is because of the criminal act that still hasn't been seen, and we're waiting for that for October 22nd.
Mm-hmm.
And I'm just asking that we follow that, because until that has been seen, all this family stuff is really like, you're kind of bypassing because the reason we're here is because I was in abuse. He's being held accountable for his counts, not for me to come into family court and be abused in a family court as well. This is domestic violence still. What is happening in family court is just a continuation. It's not physical abuse anymore. Now it's emotional, financial, mentally, right?
Okay.
So he's being charged, the defendant, he's being charged. Did you read?
I'm familiar with the criminal case.
Okay, so it says that the defendant,
Ma'am,
that he,
ma'am,
can I read this, please?
I-
Did intentionally assault Nicole Ramos, therefore recklessly inflicting substantial bodily harm on Nicole
Ma'am,
and
ma'am,
did assault Nicole
ma'am, I'm
by strangulation. My life, I didn't have my voice for over 3
Ma'am.
weeks. These are things,
ma'am.
my son
going
was
to be in contempt
traumatized
if
in
you
this.
don't
I have
stop
been as
talking.
well.
All right. I'm
The
gonna call
second
I'm gonna
account is
put
with a
deputy in
minor.
there. Can you ring a deputy? You either need to listen or
Right.
you need to not be in the courtroom, ma'am. Okay? I'm familiar with the criminal case. I've read the probable cause statement in the criminal case. I'm totally aware of the allegations in that case.
Then how
I'm
is
aware
it
of the-
right to be
Ma'am?
putting me
Okay,
in
ma'am,
financial?
listen.
God, fucking stop, Nicole.
All right. You are going to
Sorry.
be moved.
That's Ms. Shirley from the prior DVPO.
That is not Miss Shirley. You're incorrect on that as
Okay,
well.
ma'am. Okay, we're going to stop this hearing right now. If I have one more comment that isn't in response to a question, we're going to have a contempt hearing, and I'll appoint you an attorney for that.
I don't, I'm just,
You just need to listen. I'm trying to tell
thank
you
you.
something. Okay, I heard what you had to say. I'm familiar with the criminal case. That's not in front of me. There's a specific order approved by a different judge in that case that allows this to proceed forward.
Right.
And that's all I'm doing. Okay? So I'm not retrying. That case is, that's why we're not doing anything until the case is done. We're just following through with supervised visitation.
Right, but the child was in my arms when that happened,
Ma'am,
so he is,
Okay, I understand all that.
so his emotional development is important. And I'm trying to protect that because my emotional development has been hindered so much, and I don't want that to happen to my children as well.
Okay. This is on today for one issue, whether this order reflects what the order from the last hearing. And it appears to me that it does. If you have other issues you want to bring forward for the court to consider, you can file a motion and we'll look at that. Today is for one issue, is whether this piece of paper says what we said when we were here the last time.
Okay, so we're just focusing on those three.
That's all we're doing today.
Sorry,
Okay.
I haven't had an opportunity to speak with you, so.
Well, you've been in front of me in this case and several other cases numerous times with your attorney, and I've listened to everything. I've read volumes of information on this case. I am probably more familiar with the issues that are present in this case than most of the cases that come before me because of the volume of information that's been provided. And I've spent a great deal of time trying to understand all those issues.
Right.
And I recognize a lot of they're not extraneous, but they're the other things that apply in this case. This is the order that I ordered the last hearing. This is the order I'm signing today. All right?
Okay. My apologies, Your Honor.
Okay. So I've signed that order. And you'll need to work with Ms. Fellows as far as the video visitations, and I believe you're going to be coordinating that with Ms. Call, who's going to oversee those.
Ms. Cole's provided for dates to Ms. Fellows already, so they're coordinating that directly between the two of them.
I think that was starting next week or something like that.
Correct.
So, okay. So that'll be all today on that case.
And then there was three things that were addressed there, that the cost be split between us. And that's one thing that Heather had brought up that she didn't, and I also agreed with
That
her.
was what I ordered when we were here
Oh,
at
okay.
the last hearing.
Got it.
Okay? Okay, so that is all in that case.
Okay.
All right, so we'll move on to the next matter. Thank you. We're good. Okay. Thank you. All right. All right, and this is on for temporary. I was curious how this ended up on this docket. I know this was on Judge Hahn's docket, and she's not.
Judge Evans was filling in for Judge Hahn last week. I understand he did as well today. A disqualification notice was filed prior to that hearing, so it was automatically bumped to your honor this afternoon. Not necessarily by agreement of the parties, although we both agreed. I think they just naturally did that, and everybody was fine with that.
Okay, I was just curious because we'll go ahead and handle this part of it, and then it'll probably end up back on that docket for future.
Summer schedules are always tough. That's right. When people are in and out.
Yeah, it's true.
Yeah.
Okay, so go ahead, and I did review all of the motions and supporting declarations, so I think I'm ready to go. Go ahead.
And Judge, just one preliminary issue that I have in review of the pleadings. I'll certainly get to the base of this in my comments, but I would just note for the record, there was quite a bit of new information that was provided on SIR reply. A lot of it that I did discuss with my client, but clearly we weren't able to get out in any kind of declaration in response to that. There's information related to text messages that frankly don't have much of a foundation, if any. There's also additional allegations of domestic violence that are raised in there that isn't in response to anything that my client stated to the court in his pleadings, but nonetheless comes as somewhat new and surprising information, given where we were at the time that we did file our responsive declaration from my client. Just ask the court.
Are you speaking to the August 1st declaration?
I'm sorry?
Are you speaking to the August 1st declaration?
Mine doesn't have a conforming stamp, but it appears that that's when it probably was receipted in by the court. That looks like it was signed by Ms. Almedo on July 31st of 2024.
Okay,
So yes, more than likely, that's what I'm referring to.
okay.
And I can specifically object as counsel makes their arguments, but I think for expediency's sake, I'll go ahead and just leave that up to your honor to entertain what you can and disregard what you should.
Okay. All right, so counsel?
Yes, Your Honor. Do you want me to respond to the objection?
Why don't you go ahead and just make your argument, and then if the objection comes up in the course of that, then I'll address it as it comes up.
Sure. And again, I'll keep my argument relatively brief. I think the facts of this case are very clear, and the history is clear in this case. This is before the court on my client's motion for a temporary family law order. This motion was filed in June, is now being brought roughly 2 months later based on husband's intentional delays. Again, just recently receiving on the 11th hour the notice of disqualification of Judge Evans when we should have been back before the court last week. The parties were in a mid-range marriage prior to their separation in June, where my client was the primary parent of the parties' child they have in common, as well as my client brought in a child of the relationship that is 12 years old. As detailed by my client, the marriage was plagued by domestic violence as well as abuse on the part of respondent. Respondent was arrested in 2019 for strangling my client and assaulting her daughter. The basis of Mr. Danny's objection is relating to our reply materials, which show this isn't an isolated incident that occurred in 2019. That was responsive in the nature to his materials, where indicated this again was an isolated incident. My client explains in her declaration that the abuse was ongoing far beyond 2019, submits materials that personal property were damaged. Just even since filing the motion, he has threatened my client's life and continued to damage personal property through the home. So this isn't a situation that happened 5 years ago and never happened again. He goes as far as suggesting that these parties have been living amicably as roommates, which is far from the truth. My client has been isolated to protect herself as well as the children, and as she details for you in her declaration, is spending a vast majority of her time outside of the home, again, to protect the children, and while she walks on eggshells simply to get this case before the court. My client explains that she didn't agree to dismiss the action because it didn't happen. Rather, in fact, respondent in 2019 suggested that he was going to work on himself. He wasn't going to be domestically violent. And the primary concern on the part of my client is the legal basis on the fact that he is, depending on the criminal activity and depending on a domestic violent nature of a restraining order, could impact his ability to be in this country. Deportation has been always on the forefront of my client's mind.
Object to anything about the status of somebody who's in this country. That's completely inappropriate.
I'm sure that's relevant to the case, counsel.
It's relevant in the sense that it goes to the mindset of my client. The mindset of my client is that she didn't want him to be charged with a felony and be deported to Mexico because of that. Similarly, she didn't seek a restraining order in this action for the domestic violence because that could have impacted his ability to remain in the country on a temporary basis.
Again, that's well outside the scope of the declaration of pleading.
Well, there was some mention in the declarations. I'm not sure that it's appropriate to be discussing status, frankly.
I can move forward. Again, I think it's very clear from the materials, my client has been the primary parent and father has no ability to exercise a 50-50 parenting plan. He set forth no basis to support the request, and it's frankly our position that he's seeking this to limit his support obligation. My client's the parent that's been primarily at home based on the agreement of the parties and frankly as required by respondent through the marriage. So she's been home and caring for the children a vast majority of the time, while he spends most of his time outside of the home working and financially supporting the children. My client's the parent that goes to doctor's appointments. She's a parent that goes to teacher conferences. And frankly, father doesn't provide any sort of explanation based on his work schedule, how he's going to be exercising his proposed plan. His proposed plan is simply not in the best interest of the child. My client remains at home while she's seeking employment, is there for the children, and will continue to do so on a temporary basis. So we ask the courts to adopt our proposed parenting plan as is in the best interest of the child in this case. As to financials, again, my client explains to the courts that during the marriage, husband pressured her not to work, again, to be the homemaker in a more conventional sense. My client, following separation in just June, has immediately started applying for employments, which she details for you in both her original as well as reply declarations. My client is still waiting to hear back from the bank that she explains to you in her reply, but currently at this point, she's seeking employment but hasn't actually been offered employment. As to husband's income, as of July 18th, his annual gross income was $85,404. I divided that by 6.58 months, which gave him a gross of $12,979, or a net of $10,165. We asked the court, and it seems somewhat stipulated within respondent's materials, but we've asked the court to order respondent to move out immediately. Again, he was served with our motion on June 17th. It's now almost been 2 months. He's been on notice for some time. It seems like he was making preparations to move out at that point. At most, we're asking that he move out within a 2-week period. We are asking the court to provide the financial relief contained within our motion, including awarding family support in the amount of $3,500. We believe that that's more than appropriate given his $10,000 net income. We are asking for him to pay the household expenses on a temporary basis, as well as my client's car payment. We are asking for restraints relating to transferring ownership interest into the underlying property. He was making threats, as detailed within our original motion, to transfer ownership back to his boss, and we are asking for orders restraining his ability to do so. And we are asking for attorney's fees in the amount of $5,000.
Mr. Zandy?
Hey, thank you, Your Honor. Court's aware I do represent the respondent in this action, Victor Cruz Medina. My client is the current wife of the petitioner and the moving party of this action. As far as this being a mid-range marriage, it's not. This is barely 7 years in duration. These parties were married on December 21st of 2016, separated on or about June 1st of 2024, which by my math makes it a little over 7 years. Now, so this is not long-term. Certainly the RCW 2609090 does not usually support long-going maintenance durations in marriages that are relatively brief, which this one is. As far as the parenting plan, and again, I think getting back to my initial objections to this court, there is a completely diametrically opposed initial pleading filed by the wife as opposed to the reply. And that frankly is concerning. As it relates to the parenting, it all ties into that. The well-being of this child who loves and cares for both mom and dad. This little boy runs to my client, hugs him, doesn't want him to leave for work, has a similar relationship with mom. I think it was highly unusual when we got mom's reply where she says, well, he's re-victimizing me, when quite literally my client says, quote, although my wife and I had significant issues in our marriage and did not make for good partners, we are both very capable, loving, and nurturing parents. We both value our child and his well-being. That's not typical of a domestic violence abuser in my experience. So I'm not sure what the wife looked at when she says that he's trying to re-victimize her when he's claiming that both of them are caring, suitable, loving parents that can provide for this little boy. Simply because the relationship failed and they weren't good partners is certainly not a basis to punish this child who, again, is closely bonded to both mom and dad. That's first and foremost. Absent some kind of extraordinary circumstance, and there quite literally is none. Wife points to this history of domestic violence. And again, I want to specifically remind the court what she states in her initial declaration that was filed back in June. She says, while respondent hasn't been physically violent since this incident, she's talking about the one over 5 years ago in 2019, I remain in fear of him. You go to the next paragraph, it states on line 20, I do not believe he is a danger to our son. So if you look at that information from her initial declaration in which she's trying to support her need for significant financial support, that we would certainly deem as unnecessary and unreasonable. I'll get to that momentarily. She then completely changes her tune in the reply after getting my client's declaration, in which he tells this court not only is he a good parent, but his wife is as well. And again, this is one of those rare cases where we can both sit there and say, great for them. That bodes well for this child's future. That bodes well for this child's relationship with both mom and dad. She then states, which again is interesting, respondent attempts to re-victimize me by making generic, baseless allegations about my role as a wife and mother, by apparently calling her very suitable and very loving to this child. She then states, despite his claims to change in 2019, respondent has continued to be violent since he assaulted me. And again, directly in contrast to what she said only a few weeks prior, when she says, while respondent hasn't been physically violent since the incident in 2019, I remain in fear of him. So if we're looking at posturing and we're looking at domestic violence, we're looking at all these different things, again, I think that's completely disingenuous, completely contrary. And if somebody's playing to its audience and trying to gain some kind of sympathy or exasperate a problem, I think it's clearly the petitioner in this case. Let's look a little bit further than that. We look at the incident in 2019. Again, for some reason, it appears that counsel is trying to give her client some kind of realm in which she can make charging decisions, she can make plea agreements. That's not the case. This case was mitigated down to a simple assault, non-domestic violence. If you look at the pleadings by mom, and again, that's not contested. If you look at the pleadings by mom, Although she has 191 factors, there's no requests for restraining orders. She doesn't claim that the child is at all fearful of dad. Again, in her own words, she states that he is a suitable custodian for this child. Everything is contrary to what it is she's requesting. It's only until her SIR reply that we hear about all these allegations and things that my client can't respond to, when all he wants and his primary objective in this case is to have a good relationship that he's always had with this child and continue on to that. The issue in 2019, it occurred, and we certainly dispute as it was presented by the wife. That's water under the bridge from 5.5 years ago. This is a case in which these parties reconciled. This is a case in which these parties continue to co-parent not one, but 2 children, as Mrs. Almeida has an older child, Aaliyah, who is 11. This is one where she left Aaliyah in the charge of my client, and they enjoyed that relationship again to this day. So to go back 5.5 years seems extremely convenient for her and extremely disingenuous given her initial comments, which we would largely ask the court to entertain, and when she says she does not believe that my client is a danger to their son because he's not. It also kind of reeks to the honesty of this when you consider that these parties have continued to reside together since they contemplated their divorce back in the spring. She files for divorce and everybody agrees that the marriage is over at the beginning of June. What's happened since that time? Well, my client tells you absolutely nothing. They've been able to live under the same roof now for 2.5 months. They've been able to continue to co-parent, not just Victor, but Aaliyah as well together. They've continued to be able to make financial arrangements. He continues to go to work. He continues to provide the household expenses. There hasn't been one iota of anything that's been inappropriate, any domineering behaviors, any assaults. And again, until we get the reply declaration, one could certainly submit, if it was as bad as she is claiming, a restraining order or protection order or some kind of relief would have been requested. We have none of that. So again, there is certainly no justifiable reason that my client should not be a very active part in this child's life. We would propose a joint parenting plan. I think that's best interest of this child because he is closely bonded to both mom and dad. Because we don't have anything to give rise to 191 findings outside of mom's comments, which again are all produced on SIR reply after we file our initial paperwork. So again, my client does believe that that will work. My client gives you information in which he says he's one of those lucky individuals, works for an employer who is willing to work with his schedule so that it can accommodate any visitation, so it can accommodate the school schedule of Victor. And my client tells you he is more than happy to do that. This is not the guy, and this certainly is not the declaration of this violent person who wife now suddenly and conveniently claims that he is. In contrast to that, my client does detail you some concerns about his wife and some of her behaviors. Again, I think this is all fodder for a GAL to look at and review and contemplate where the truth lies on this. But where we sit today, we've got 2 parents and 2 parties who could not get along and salvage the marriage. They tried to both of their efforts since 2019 to do that. It didn't work. But we have 2 parents who are very capable and more than able to care for this child who, again, needs both mom and dad in his life. That gets to the house situation. My client details for you, yes, I think everybody agrees, this was purchased under a 30-year contract from one of my client's former employers who he still remains somewhat close with. That home was purchased a couple of years ago. There's still a mortgage on that. It's $1,600 a month. What does my client detail for you? He understands the reality of this. He understands that he is in a financial position where the court might make him go, not because you're making any ultimate determination on that, but because he wants consistency not only for Victor, but for Aaliyah too. And that's where things get a little bit complicated. Even though we don't have any rights to Aaliyah, even though he is a step parent at this point, he still wants what's best for her. Again, does that sound like somebody who is vindictive and angry and controlling? I would certainly suggest not. My client does tell you that if you are inclined to order him out of the home, we would like a little bit of a period to do that. We've suggested the end of September. He has begun looking. He has found that most of the rents in the semi-local area, and I'm talking probably between Willamette and Ridgefield, so that he's relatively close to Woodland where the child goes to school, are exorbitant at this point. You're looking at minimum $1,800 for a 2-bedroom, 1-bath. If you want a 3-bed, 2-bath, exponentially more than that. He's realistic about that. Anywhere up from that $1,800, probably $2,200 or $2,300 per month, depending on where he's living. Inventory, as he details for you, is limited in Woodland. He still continues to look, but he wants a place, again, that's suitable for him, comfortable for the child, with the hopes that Aaliyah can come visit him too, as he's been a very integral part of her life since the onset of the relationship with the petitioner. So again, this isn't somebody who's trying to domineer his way into some kind of a bully tactic to get what he wants. This is somebody who's objective about the process and tells you I'm mostly concerned and primarily concerned with my relationship with my child. And what mom proposes in her parenting plan of him having essentially 2 overnights a month certainly is not appropriate given what he's done. This is a man who's provided for not only his family, but Aaliyah as well. This is a man who has jumped through many hoops. He details those for you in his declaration that Mrs. Almeida made him jump through pertaining to her family, moving them, bailing them out of jail, doing those types of things. Since 2019, he has largely been under her thumb. And again, it doesn't matter why the marriage broke down. It's in no fault state. What matters is that we protect the best interests of Victor and give him equal access to my client just as we would to his mother, which again, the child deserves. If we looked at finances, and again, this seems pretty simple, and the reality is Mrs. Almeida needs to get a job. We understand, and I would ask the council discuss with her. It appears she got that job at the bank. It appears she's making somewhere in that $25 an hour range. Somewhere in there, we would ask the council detail that with her and confirm. For purposes of income, I've simply asked that you impute her in a wage that we believe is reasonable at $3,200 per month. That would coincide with what she's getting on that approximately $25 an hour if that's what she's making at the bank. So I think that's one that goes in there. She has work experience. She's done the housekeeping. She's worked at UPS. She has these jobs where she's had benefits in the past. We do not agree with council's argument that my client said, well, you should stay home and not work. In fact, my client details for you, it was the opposite of that. He encouraged her to go to work, and the response was, I don't need to. You make enough to support the family and me to live comfortably. We're not in that position anymore. And so if she's not working at the bank, she needs to find a job. She needs to provide us with actual applications, actual places that she's applied, as opposed to, well, I applied at Lazy Days RV and I might have a job there, which again was, looks like sought out about 4 months ago. She needs to make more of an earnest attempt with that, especially now with school starting and her being home all day. As for my client, and again, pretty simple calculations. We provided you with a recent pay stub from July. We've also given you some tax information that show gross earnings in 2023 of $121,509. If you take that figure, it's about $10,125 gross per month. He's making more money in 2024. And again, the pay stub indicates that, but not significantly more. For purposes of his income, I simply took his year-to-date net income through that July pay stub. I believe it was July 14th, showing net earnings per month of $8,317. And again, that simple division from the year-to-date net divided by the 7.6 months or 7.4 months that was calculated, which gives you that $8,317 number. Looking at that, that's what we're asking. If you look at the obligation, and again, Mrs. is essentially asking for $3,500 per month cash. She's asking my client pay $1,600 for the house and what she lives in. She's asking he pay her car payment of $359 per month, and basically all of the expenses, which would leave him with approximately $1,000 a month to live off of when he's, under her theory, going to have to relocate. Again, that's certainly outside the realm of reasonable. Certainly doesn't make good sense given the logistics of this case. If you look at what's obligated, again, in addition to that $1,600, my client's going to need to find a new place to live. We use the lower amount of that $1,800 per month. Utilities at $400, groceries at $450 for, I'm going to call it 2.5 individuals, not knowing what's going to happen with Aaliyah. He's got the mortgage contract of the $16. He's got moving expenses. He's got his truck payment of $660, her car payment of $359, a consolidation loan of $400, plus the credit cards. And again, this is undisputed. She doesn't make any comment or dispute any of this in her reply declaration. There's the American Express of $120 a month, Capital One of $100, Apple Credit of $50, Fortiva of $50, Les Schwab $100, and then the immigration legal services for attorney's fees, which is about $250 a month, $500 a month, plus gas and vehicle expenses, families insurance for auto and health. He's paying literally everything, and she wants more than that. So again, if we look at the reasonableness of that, I would certainly suggest it's not. And then she's asking for $5,000 in temporary fees and costs. So there's just simply not enough money to go around. Our suggestion is that you adopt our parenting plan. My client doesn't care if that's week on, week off, or 4 on, 4 off, or whatever you deem appropriate. He will make it work. He has thought through this. He has talked to people. He's made connections on how this is going to look. He's ready to go. And these are parents who are splitting households. They're going to need to figure this out. So that's what we're asking for. Also asking that there be any child support based on what we do with alimony, that it be deviated down for the overnight residential credit. Again, I think that's appropriate. If we combine that as family support, again, I would encourage you to consider the $1,600 a month he's paying for that mortgage. That preserves the equity. It also gives her a place to stay. That is a form of alimony or spousal support. I think that's appropriate. It's also spousal support to consider that $359 per month car payment. Also spousal support for him to continue paying for the insurance, both medical and auto. Again, all to wife's benefit, while she apparently, hopefully now just got a job, but it alleged previously in her counsel's comments today, she still doesn't work. So again, that's the request on that. So if he continues to pay those bills, he tries to, again, find suitable living if you, in fact, want him to vacate the home for himself and the child. That's a big expense. And that's what it largely comes down to. It's just not enough money to go around. And Mrs. frankly needs to get a job and go to work. So that's just kind of the reality of it. That's where we are. Right? And hopefully a GAL, if the court appoints one, and I think this case is probably ripe for that, the court does appoint a GAL. My guess is they're going to look into this pretty far and see that this is a little boy who loves both mom and dad. And this is a mom and dad. And the court doesn't get these all the time, that are both capable of providing for this child and caring for this child and providing what he needs, and despite of their differences that they had as a married couple. So again, that's a request. It's certainly reasonable. From our standpoint, our proposal meets the child's best interests, also provides for the wife adequately when it comes to the support side. That makes the most amount of sense moving forward. Would ask, considering he's going to be paying largely all of the community debt, plus whatever it is that he's going to be living on, we ask that attorney's fees are reserved or frankly denied given the circumstances. Again, I would renew my objection based on a lot of new information that we could not respond to along with exhibits. My client has an answer for all of that, but unfortunately based on when it was filed, and it looks like it all predates their initial submissions, by the way. And we would ask that any new information not be considered.
All right, thank you. Ms. Gilmore, any response?
Yes, Your Honor. First, I would like to correct the record. I'm looking at my initial declaration in support of our motion. There's been some mischaracterization of what we've submitted in our initial material. I want to clarify that for the record. Specifically, I'm looking at my client's declaration. She states, respondent strangled me and broke my phone when I tried to call for help. Respondent then proceeded to pick up my daughter by her hair and throw her into the room. I was worried respondent would be deported and decided to later drop the charges. We continued to live together since that time. While respondent has been physically violent to me since this incident, I remain in fear of him. Respondent is verbally abusive, will throw things, and is controlling over my finances. Looking forward to the parenting issues, she states, while I'm concerned about my safety relating to respondent's domestic violence, I'm cautiously do not believe he's a danger to our son at this point. So the characterization that my client is bringing before the court no concerns of domestic violence and then provides new allegations within a reply is just simply not accurate. This has been the theme and ongoing throughout their marriage, and my client presented it in her original materials. In relating to re-victimization, respondent had the audacity to claim that my client was violent to her, which isn't warranted by any facts, and that's the basis for that. As relating to, again,
object to that, we certainly didn't say that she was violent towards him. We said she was controlling towards him in the nature. I don't know where that comes from. So I was just saying I would continue to renew the objection.
Okay, objection is noted. Go ahead.
and again, in response to the claim that they've been working together, are friendly, and roommates, my client provides new information, or in response that he has threatened her life since filing this motion. So that is responsive and should be considered by the court. My client is a survivor of domestic violence. She did her best to keep this family together. She did her best to avoid legal consequences for respondent being in the United States. I understand the court's standing on that, but that is a consideration regarding to my client's mindset. So when looking to the legitimacy of her claim, we must consider what she was thinking at the time when she was making this. Counsel, Ms.
Yeah, this is a charging decision made by the authorities. She doesn't dictate to the prosecutor's office or the police institutions what they do and what they charge. So I think, again, same objection.
So I guess I've got concerns about that. I mean, the victims, alleged victims in cases don't make charging decisions.
If they're the only witness available and they're not willing to testify, I definitely, as a previous experience working in a prosecuting attorney's office,
Well, again, I'm going to object to anything outside the scope of the plea.
Okay, I'm
Counsel
limiting to the
disagree.
pleadings, and I think I'm going to sustain the objection.
Okay. Moving forward, I'm happy to provide updated information. Last I spoke with my client last week, she still was waiting to hear from the bank. I don't think it's appropriate, Mr. Zanny requesting for his client's income to be considered from 2023 earnings. We're now midway through August. I provide an income analysis that's accurate for his current earnings, and we do ask the court adopt that. Council misstates our proposed parenting plan. My client, in fact, is asking for more consistent contact for shorter periods of time to coincide with respondent's work schedule. My client is asking for him to have every weekend for one overnight because he works on Saturdays, and he's failed to provide within his materials who is going to provide support when he's unavailable, when he's working around the clock and goes to work at 6 a.m. Lastly, looking to the request for support, my analysis and request for family support amount of $3,500 is based on him having net income of $10,000. If you reduce the $3,500, that gives him another $6,500. Roughly, that's another additional $1,500 to $2,000 in costs, which gives him almost between $4,000 and $5,000 to live a month while he's solely supporting himself. And again, we have no information of where he's actually going to live, if he's actually going to rent, and if he's actually going to incur said costs. He very well could live with family, I'm unaware. So we do ask the court to provide the relief herein. We ask the court adopt our parenting plan. We ask the court provide family support. And I think attorney's fees are warranted in this case. This is an individual that's making a substantial income, has made substantial income throughout the marriage, has failed to provide any sort of bank statements at this point, suggesting that he has an inability to pay. My client explains in her declaration he's made prior statements about hiding money. So this is a person that can
I
pay
would object to that. That was just introduced on the SIR reply, and they have certainly responded to that.
All right. I'll sustain the objection. Go ahead.
We can move forward with the ruling, Your Honor.
Well, I'm going to ask you to supplement your pleadings on both sides. Looking at I'm looking at your client's, and I'm speaking to you, Ms. Gilmore, I'm looking at your client's financial declaration, and she's indicating expenses of $3,646, but that would include her making the house payment, which he's asking not to do. So I guess I need a new financial declaration that shows what she's actually proposing to pay out of the money that she's got. And then I need the same thing from him. So I can't really make a ruling on finances today without that, because I don't have what his budget is. The proposal is that he pay all the bills that are existing, which I don't know what those total up to on a monthly basis. And she's got some of those bills in her budget. So I don't have an accurate budget based on what her needs are based on to make a family support order or a child support order. So I'm going to ask you both file updated financial declarations that show the budget that they're each paying out, so I know what I'm working with. I don't have that.
So understood, and I'm happy to do that. If you look at responsive declaration, page 6 of my client, he lists for you the expenses, and then by our totals, and this is at the low end, $8,069 per month. And again, that doesn't include a lot of the other stuff that would plug into that financial declaration. I anticipate that number is probably going to inflate to north of $9,000 a month. If you adopt what we're proposing, I'm happy to put that down in the
It may, but I just need to see those.
Sure.
Because I don't have an ability without spending several hours trying to go through and sort out the numbers, which I've got amount owed, I've got amount payments are on hers on at least some of those bills, but she's asking he pay all those. So it's unclear who's the proposal that you're each asking on the financials. So I'm going to ask you to update those. We obviously need a guardian ad litem in this case. So I don't know if you want to do that today.
Yes, please.
Who's our next three?
Are Amy Turnbull, Ann Height, and Karen Lawrence.
I will strike Amy Turnbull.
Ann Height's sufficient. Thank you.
Ann Height is what? I'm sorry, counsel.
Ann Height works for me.
Okay.
Okay, so Ann Height will be appointed. At this juncture, well, I guess I need to see what the numbers are as to who's going to be paying that, and how that's going to be paid. Probably at least a portion of it will be private, given the total income. But I need to see what the actual budgets look like. I think given the differences in the parties' positions, that probably staying in the same house financially would make sense, but not otherwise. So at this point, I am going to leave the kids in the house. I'm going to leave mom there with them. So primarily with mom, I'm inclined to, I guess I'd like to get some kind of a quick response back from either a guardian ad litem or an investigator as to the temporary contact. We start out generally with 50-50, but there's a lot of allegations in this case, which adjust that to some degree. And then again, I don't know what, if mom is working or going to be working, what her situation is going to be as far as being there for the kids during the week. So that probably getting some input from the guardian ad litem on that would make sense. As far as the 191 factors, I'm going to reserve on all those at this point.
I'm sorry, what was that, Your Honor?
I'm reserving on the 191 at this point. Let me see here. As far as if I'm reading your proposal, you're proposing essentially 3 overnights a month. Is that accurate, Ms. Gilmore?
Would be 4, and I did misspeak. I read that parenting plan wrong. It's every Saturday overnight to Sunday, but again, he's had the kids all week. She is working. She went to work on Wednesday, it looks like, of last week.
When I have to object, that's new information I don't have in front of me.
That's information we should have.
Well,
I asked her.
Well, guardian ad litem's going to look into that. So he's obviously going to need to find a place. I think end of September, probably a long stretch. Probably by the end of this month, that's about 2 weeks out. Makes more sense. So he should be out of there. He should be have someplace secured by the 1st of the month. And then I guess my thought is maybe we need to put this over to about the 3rd, and then I can maybe we can get something from a guardian ad litem that quickly as far as temporary placement and contact with the kids. I don't know, is Miss Height on here at all?
If that's, so you want to enter the order today?
We can do that. Problem is I don't have all the finances to where I can make a good ruling on.
Just go 50-50, and then we can reserve on, if you want to tweak that down the road, would be my suggestion.
He's historically, my client had an income of 0 based on the pleadings, and he has an income of 140. So I don't think 50-50.
But we don't know what we're going to do with the finances yet.
And I don't know where the finances are. What I'm going to do at this point, I'm going to do it at public expense, and then that'll be adjusted once I see where we're at actually with the numbers. So we can get an order going on that. I don't know if you want to fill out a bench order or counsel, if you want to submit that later. And then I could put a review on, I could put it on my docket on the 3rd as far as all of these issues. That way we would maybe, I don't know if Ms. Height, I was hoping she was on. I don't see her on here though.
But if we're going to do that with that quick of a turnaround, that's only 4 days after you're ordering out of the house. What I don't want to have is we don't have any business. He's out of the house at the end of the month. The GAL is appointed, but needs the 3rd doesn't work. So Miss Height's usually really prompt and quick in turnarounds with that. I just don't want him going extended period without seeing the child, because that would devastate this kid who loves his dad. So maybe we just order that stays in the house until we have the review hearing, which is going to be right close to when you set it anyways.
Well, I want to have him working on getting out of the house, and we're having a review 2 days after he needs to be out of the house. So I'll be able to make a decision once I know that, and I have the finances a little more lined up. So we'll set a review at 1 o'clock on the 3rd. At this point, I am going to require that he pay the house payment. That's going to be at least part of the ultimate order in the case, and best efforts on the balance of the bills.
I think he's already done that. The mortgage was due on the 5th of August, so they're paid through August. And if we come back on the 3rd, I guess we can just.
Well, if it's due on the 1st, it still needs to be paid for next month.
On the 5th, isn't it? 21st.
And then I'm going to kind of work back from that on everything else on the finances. And then as far as short term for the next couple of weeks, he's still going to have a lot of contact with the kids, and I'll be able to get a more detailed plan going forward.
That seems amazing, but that's only 3 weeks away for September already. This is going to put us in a spot where Miss Height might get us something if we're lucky that Friday before the hearing. Are we just going to go kind of off the cuff at that hearing on the 3rd you've heard the arguments from both sides and just have the GAL.
Yep, I just like to have some input from her, given the circumstances. I mean, I have something in my head when I'm looking at it on the short term that it would be subject to guardian ad litem review anyway.
Just come back, yeah, okay. All right, fair enough. That's back to the GAL order. I'd like to get that in there tomorrow if we could. Council has, you got time to do that, or you want me to do it and forward it to you?
Yeah, I have to run out to that appointment today, but I can either draft it in the morning or I can sign it tomorrow.
Okay, one way or the other, we'll get that out hopefully and then present it ex parte so we can get that going.
Yep, that can, and anybody can sign that on a short
Right,
term.
okay,
So,
very well, thank you.
okay.
Thank you.
So review it on the third. You're involved in that, Mr. Zandy and Ms. Bliss.
Can you take care of that real quick? That's a short one. Is Ms. Bliss, there she is.
Yes, I'm here. Thanks.
We have come to a resolution on that on a temporary basis.
Okay.
And didn't have time to draft that, reduce that to writing, but nonetheless, I'll go ahead and do that with the following agreement put on the record. Now, we've agreed to a GAL being appointed on this, so we're gonna need the next 3 names.
I assume that's going to be Turnbull, Lawrence, and whoever's next.
So the next 3 names are Karen Lawrence, Keith Lawrence, and Twyla Corey.
Any preference, council? I'm good with it.
So is Keith, Karen, and Ms. Corey?
Yeah.
Okay. I would strike Ms. Lawrence.
Okay.
So I guess whoever's next, unless you have a strike.
No, I'm fine with Keith Lawrence on that.
Okay.
So I'll draft that into the order.
Okay.
We didn't talk about the percentages for that. We need to. That's the one thing we did omit inadvertently today. Attorney's fees, my client's request for those is going to be reserved outside of the 750 that was previously ordered by Judge Scudder last month.
Okay.
Largely, my client's proposed parenting plan will be adopted. Now, there will be no direct visits with dad outside of the telephone communications that the parties have been able to do effectively since the date of separation and since my client has been in Washington. So we're basically trying to keep the status quo for that. So the language will say telephone communications as agreed and arranged between the parties pending guardian ad litem investigation and recommendation. The children are not to be exposed to any romantic third parties of either parent or subject to any inappropriate relationships. For support, and the rest of my client's proposed parenting plan has been adopted. As it pertains to support, Mr. Sane will pay $1,500 per month in child support effective August 1st. We will reserve on any back support that may be owed. And as far as payment of bills and the like, my client will continue to use the credit card she has been using historically over the past several months. I think that's a Capital One, but council and I again can confirm that. In addition to that, Mr. Sane will continue to pay that credit card in the same capacity he has and provide proof of that as needed. He will also pay the Chase, Wells Fargo, and Bank of America credit cards along with PSEG, which I understand is a utility bill, and his own cell phone. I think that concludes the agreement for now, and then we can come back once we get GAL information. Correct, council?
Yes, the only change that I don't believe that we discussed, but it was kind of assumed by me, so I'm hopeful that this doesn't blow everything up. I was going to ask for reservations on 3A and 3B of your parenting plan, pending GAL input.
That's fine. Yeah, I think that was understood.
That makes sense.
And I think otherwise that's fine. I was able to confirm, Mr. Zaney, and I can send you the statements that I do have. It is a Capital One card that she is an authorized user on, and he agrees to continue paying that. As for any other credit cards, he claims he doesn't have any. So I guess I would just say any other credit cards in his name or in either party's name, he'll continue paying.
It probably for a GAL, it would seem that she's probably, given the circumstances, as I understand it, would be on county expense, and then he would be private pay, I'm assuming, unless there's something I don't see.
That would be my understanding as well, given her
I don't
income.
disagree with that, so that's fine. So she'll be county pay and he'll pay whatever the remainder is of that.
Correct.
Very well.
And I guess, Mr. Zaney, if we're just looking at your child support worksheets, which we're largely working off of anyways, it would be 86% him, 14% her.
14% county.
Exactly.
That's fine.
And then I'll draft those orders hopefully around the same time as that last case and get those over to council, maybe a day or two later, and hopefully have those entered by the end of the week.
And I would just note, my withdrawal is effective as of Monday, so preferably before that, so we can make sure we can get these orders entered before.
I gotta be quick then.
And I will
Yes.
I will be out next week, so.
But I think we'll probably be agreeable to send them to whoever's here.
Sounds
Yeah.
good.
All right.
That's fine with me. Thank you.
Thank you. Okay, so I did note that the protection order was terminated last Monday, so that is no longer in place. And I do have the guardian ad litem report from Ms. Lawrence, which obviously raises some concerns. And then I understand the parties have come to a different agreement that would not be necessarily consistent with that. So, Ms. Lawrence, before we proceed, do you have any other comments that you'd had about this case at this point?
Just that I'm very concerned that Mr. Olmos hasn't engaged with law enforcement and the little kids are still in his household, and I find that disturbing.
Well, the two things is that I don't know that I have any ability to order him to do anything with law enforcement specifically.
May I say something, Your Honor?
Yes, sir.
Your Honor, I love my children with all my heart, and I would do anything and I can for them, and I would never endanger their lives. I've been a consistent father for 9 years. I've done everything to support them and give them a loving home. I've been consistently a dad in their lives. Since COVID, I've worked from home and I've been with them 24/7. You know, I love my children with all my heart, and I just pray that you allow my children to have both their mother and their father equally in their lives. I just wanted to say that, Your Honor. I apologize. It's nothing fancy or, wordy or anything. I just wanted to spell out my heart to you. Thank you, Your Honor.
Thank you. So, and Ms. Tina, I see you have logged back in. Are you with us on this case?
Yes, I am, Your Honor.
All right. So, and you received a copy of Ms. Lawrence's report?
Yes, we did. May I say something as well?
Sure, go ahead.
As I've already told Judge Evans, our children have been through enough trauma. I know that George is not a danger to his young children. I don't know what's going on regarding the investigation and him complying with law enforcement. I just know that he's been a good father to our children. So I think that our children have been through enough trauma, and I don't feel that they need to be taken away from their father. I mean, they've already been through enough with having their mom taken away for 10 months. Do I wish I knew what was going on in the investigation? Absolutely. All I know is what I can go off of, really.
All right. And you, Ms. Lawrence, you've not received anything more from law enforcement. They've essentially asked you to not proceed. Is that my understanding?
That is correct. I have received nothing more from law enforcement, and the allegation is so credible from Ms. Tenna's 13-year-old that is just terribly concerning. More so, as I detailed in the report, what Mr. Olmos's response was to it when he was questioned about the allegation from Ms. Tenna's daughter's biological father, and that really should be considered.
Miss Lawrence is lying, unfortunately.
Well, Mr. Olmos, I don't have any reason to believe that. She may have a misunderstanding about something or something like that, or perceive something differently, but that's
possibly
appropriate.
Yeah, I apologize, but that's incorrect, Your Honor. I apologize.
What are you folks doing right now with the kids as far as contact with both of you? They're with you, sir, or is Miss Tina seeing the kids?
I had the restraining order lifted. So since the restraining order has been lifted, I lifted the restraining order on me as well. So she's been seeing the kids, yes. It's the kids love her, you know.
Ms. Tina, can you tell me what that's been like since last Monday? Or whenever that was done? Your contact with the children?
Well, Your Honor, like I already stated prior, I was seeing the kids even with the protection order on.
Mhm.
But it has been a weight lifted off my shoulders. It's not something that I have to worry about. The kids are fine. They're happy. They're 3 and 4 and 9, and they're 3 and 4 and 9-year-olds. So they cry, they are happy, they make up. They just it all depends on the day. But they're not in danger, and they're not unhappy. And they get fed, they get clothed, they get showers. Getting the 2 youngest into school soon, hopefully.
Ms. Lawrence, are you aware of any activity on DCFS or DSHS on this case?
Yes, there was an open case, and so as a result of that, we can't get any records until it's closed, and I have not been notified of that.
A current case with our local office?
Yes, it started by with the law enforcement thing on Easter.
So I think this is, you folks are in kind of an unusual spot, a kind of a legal quandary that puts the court in. It would seem to me that to move forward on this case, I mean, you folks have some agreements as far as your contact with the children on a short-term basis. I kind of need to see the outcome of the DSHS, DCFS investigation and proceedings as to what their plan is. If they're planning on moving forward, that impacts this case. If their decision is they're not going to move forward based on whatever they're going to make that decision, that changes things a bit. They haven't obviously filed anything because I haven't, at least not that I'm aware of.
That's correct. Unfortunately, we commonly get caught in that loop between CPS and law enforcement. CPS will sometimes wait for law enforcement, and when nothing's happening from law enforcement, CPS will just kind of sit on it for a little while, and then they'll review it in a few months and then toss it out as non-responsive if law enforcement doesn't come up with anything. I don't know what to do with it, Your Honor.
I understand. And I obviously have got concerns based on everything that's in your report, as well as this is a concerning case. There's a lot of issues that on the other hand, if parties have come to a certain level of agreement between themselves, which the court has to consider that at some level. My thought on this would be to put this out a bit. Maybe if there's any possibility you could re-inquire of DCYF or DCFS as to what their status on this case is, to advise the court. And then I'm not inclined to make any changes. We haven't had really a hearing to hear from all the parties. I mean, I could schedule a hearing. I'm not sure that that's going to be particularly useful given what I know what everybody's position is, I think. But I'd like to see if we've got some kind of response back from the department.
I'm happy to do that.
If
We'll see if we get a response. I've been particularly slow on getting comments back here in the last 4 or 5 months.
Well, and we are in the middle of summer. And I thought, why don't we put this maybe like the 10th of September? So I'll give them an opportunity with some kind of a deadline that we're going to be reviewing the case and determining how to move forward. In this case, it would be very helpful if the department's what they're moving forward on or not.
Okay, sounds like a plan to me.
Okay. So, Mr. Olmos, Ms. Tina, I'm going to leave you kind of in the status quo you're in. You're working together, obviously, to have contact with both of you and the kids. I urge you to continue to do that. I just don't think I can move forward on a final decision on this case, even by agreement, without at least getting some input back from the department since they have an open case. So I'll have Ms. Lawrence reach out to them, see if they can give us a status report as to whether they're going to move forward or if they're dropping their case or whatever they're going to do. And then I can hopefully come up with a better answer. Okay.
Sounds good.
Sounds good. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
I'll set this at 1 o'clock on the 10th of September for review. Hopefully an update.
10th of September. Okay. Thank you so much.
All right. You're welcome.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. I believe that is everything on today's docket, so we will adjourn.